bench press assistance.
What?
Due to excessive gym volume, all available spotters are currently lifting heavy weights off the chests of other bench pressers.
Seriously?
Please continue to hold, and we will remove the barbell from your chest in the order in which your cry for help is received.
Getting assistance should be easy. With Progressive, it is. Progressive Casualty Insurance Company and Affiliates.
You're listening to Federal Appellate Panel Rejects Trump's Deportations Under Wartime Law, a news story written by Jeremy Roebuck and read by an AI-generated voice. A federal appellate panel ruled Tuesday that President Donald Trump unlawfully invoked a centuries-old wartime law to deport Venezuelan migrants, finding no invasion or predatory incursion had occurred to justify using the statute to fast-track migrant removals. A divided three-judge panel of the New Orleans-based U.S. Court of Appeals for the Fifth Circuit granted a preliminary injunction barring deportations under the 1798 Alien Enemies Act. The decision from the panel, composed of judges from one of the most conservative appellate courts in the nation, is widely expected to be appealed to the Supreme Court. Trump declared the Venezuela-based Tren de Aragua gang a foreign terrorist organization in January, and 2 months later invoked the act to send 137 people, whom the government accused of being gang members, to a notorious prison in El Salvador. The Trump administration has asserted that the gang is carrying out an invasion of the United States at the direction of Venezuelan President Nicolas Maduro's regime, a conclusion questioned by U.S. intelligence agencies. The Alien Enemies Act has been used only 3 times previously in the nation's history, and only when the country was at war, a fact that has prompted several lower court judges to rule that the Trump administration was unlawfully using the statute. In its one ruling Tuesday, the Fifth Circuit panel agreed, finding that Trump's stated rationale did not meet traditional definitions of the type of hostile invasion that lawmakers had in mind when the statute was first crafted. We conclude that the findings do not support that an invasion or predatory incursion has occurred. We therefore conclude that petitioners are likely to prove that the AEA was improperly invoked, Judge Leslie H. Southwick wrote. His opinion was joined in part by Judge Irma Carrillo Ramirez. In a scathing dissent, Judge Andrew S. Oldham blasted his colleagues for second-guessing the president, saying heads of state should be granted wide latitude, as they have in past instances where the law was deployed to quickly deport migrants. For President Trump, however, the rules are different, he wrote. He added that the ruling contravenes over 200 years of legal precedent and threatened to turn federal judges into robed crusaders who get to play act as multitudinous commanders-in-chief. Lee Gallant, an American Civil Liberties Union attorney who argued the case on behalf of targeted Venezuelan migrants, hailed the panel's decision as a victory. The Trump administration's attempt to use a wartime statute during peacetime for immigration purposes was correctly shut down by the court, he said. This ruling makes clear that the courts are there to keep the executive branch within legal limits, and that even the president cannot simply declare an emergency whenever it suits him. The specific case ruled on Tuesday by the Fifth Circuit took an unusual path to get there. After the Supreme Court ruled in April that targeted migrants must challenge their removals in the court districts where they are being detained, immigration authorities rushed to transfer dozens of Venezuelans to the Bluebonnet Detention Facility in Anson, Texas, where only one federal judge is assigned to hear any such challenges. That judge, Wesley Hendricks, a Trump appointee who sits in the Northern District of Texas and is known for his conservative rulings, refused to temporarily pause Alien Enemies Act removals while the migrants' legal challenges played out before him. Just hours after his decision, dozens of Venezuelans housed at Bluebonnet were handed notices, written in English, telling them they had been designated as alien enemies and would be deported within days. Fearing that the government was preparing to imminently deport the migrants before their cases could be heard, ACLU lawyers scrambled at 3 levels of the federal court system, asking Hendricks, the Fifth Circuit, and eventually the Supreme Court to intervene. The Supreme Court did step in. In an extraordinary middle-of-the-night order, the justices temporarily barred Alien Enemies Act removals in Hendricks's district, while they considered whether the migrants had been granted enough time to challenge their removals. Weeks later, the justices renewed that hold on deportations as they sent the case back to the Fifth Circuit, setting up Tuesday's ruling. This is a developing story and will be updated.